Hi everyone. In this video, we will be reviewing the contents of the Human Tissue, Transplantation, Post-Mortem, Anatomical Examination and Public Display Act 2024, which was signed into law on the 28th of February 2024, but which only became operational on the 17th of June 2025 by virtue of the enactment of Statutory Instrument number 250 of 2025. Noting that only parts 1, 2 and 6 of this law have become operational on the 17th of June, so I will confirm which sections are operational and which sections still require a commencement order to go live as we go through the video. Firstly, I want to explain how an Act of the Oireachtas can become operative in Ireland, as this can happen in one of two ways. The first is where the Act includes a specific commencement provision in the Act stating the date or dates on which the Act will apply from. The second is where the Act includes a provision stating that a commencement order, which is a type of statutory instrument, is required to be enacted by a minister to bring the Act or a specific part of the Act into force on a designated date. So when an Act is signed into law by the President, it does not automatically take effect unless and until the minister issues a commencement order. This is very common, and this is why this Act was signed into law in February 2024, but only became operative on the 17th of June 2025 as we were waiting for a commencement order to be issued, and this happened on Tuesday of this week with the issue of Statutory Instrument number 250 of 2025. Now we will take a look at the Act, which in summary establishes a legal framework governing organ donation, transplantation, post-mortem examinations, anatomical examinations, and public display of human bodies. The Act is split into 6 parts as follows. Part 1 is titled Preliminary and General and includes the definition section, confirmation that the Act will become operational in sections through statutory instrument commencement orders, and also confirms the fact that the Minister may publish guidelines for the operation of the Act. This Part 1 of the Act was commenced on the 17th of June 2025. Part 2 is titled Transplantation and introduces the concept of deemed consent to organ donation, which arises when an adult with capacity has not included their name on the HSE's organ donation opt-out register before their death. This Part 2 of the Act was commenced on the 17th of June 2025. Part 3 is titled Pathology Practice and focuses on regulating post-mortem examinations, both coronial and non-coronial. This part of the Act has not been commenced as yet. Part 4 is titled Anatomical Examination and regulates the use of bodies for anatomical examination. This Part 4 of the Act has not been commenced as yet. Part 5 is titled Public Display and manages the public display of human bodies or tissues after death. This Part 5 of the Act has not been commenced as yet. And finally, Part 6 is titled Miscellaneous and allows for the amendment of other pieces of legislation, including the repeal of the Anatomy Act 1832. This part also sets out offences and penalties for breaches of the Act. Some but not all of Part 6 was enacted on the 17th of June 2025. Now we will run through some parts of the Act in more detail. As I said, Part 1 is titled Preliminary and General and includes issues such as the definition section. I'm only going to run through a few of the more important definitions, but I've also included a link to the PDF version of the Act that I am working off in the description box of this video, so you can review any or all of the definitions, particularly those definitions that I have highlighted, in your own time if you wish. Firstly, the Act includes 3 categories of consent: deemed consent, appropriate consent, and consent, with deemed consent being the least acceptable form of consent, at least in my view, as there is no positive action carried out by the alleged donor to confirm that they have given their permission to have their body used by another person. In my view, this seems like the gravest form of abuse of bodily autonomy ever committed into legislation by the Irish state. Given that we have always operated on the basis that consent must be affirmative, informed and voluntary to be legally valid, whereas under this Act, provided we are only referring to the confiscation of your body by the state, silence means consent. On the screen you can see an explanation for the 3 categories of consent just mentioned. So deemed consent means consent that is assumed after your death for the donation of your liver, lungs, pancreas, heart or kidneys by virtue of your silence, as in because you have not included your name on the HSE opt-out register. For deemed consent to be valid, you must also be aged over 18 years, be living in Ireland for at least 12 months before your death, and have had decision-making capacity for a significant period of time before your death. So in the case of deemed consent, provided you meet these 4 criteria, contact must still be made with a designated family member to ensure that they do not object to donation. And the main reason for this is because your consent has been assumed by virtue of your silence rather than formally given. On the screen, you can see the defined list of designated family members in their order of priority, noting that some of the people on the list may be disregarded if you have separated from them, or if they do not have capacity to give consent, or where they are under the age of 18 years, or where they do not wish to be a designated family member. Also, if more than one person falls within any of the bullet points, they are ranked equally, and consent can be secured from anyone ranked equally. The list of designated family members are spouse or civil partner, cohabitant, children, parent or a previous guardian, brother or sister or stepbrother or stepsister, grandparent, grandchild, uncle or aunt, niece or nephew, close friend who can correctly communicate your wishes. In summary, deemed consent can only be provided by adults with capacity who have been living in Ireland for at least 12 months before their death. The second level of consent is referred to as appropriate consent, which means consent provided without duress or coercion. Number 1, in relation to a deceased adult who has not included their name on the HSE opt-out register and in respect of whom deemed consent does not apply. Consent in this case would be provided by a designated family member. 2, in relation to a deceased child, consent would be provided by a parent or guardian. 3, in relation to the donation of an organ by a living adult donor or a non-directed altruistic donor, consent would be provided by the donor. 4, in relation to the donation of tissues and cells by a living adult donor, consent provided by the donor. 5, in relation to the donation of regenerative tissues and cells by a living child, donation by a parent or guardian. 6, in relation to the donation of regenerative tissues and cells by a living adult who lacks capacity, consent by a specified person, which is a defined term. So in summary, appropriate consent is required for adults who have not included their name on the HSE opt-out register and for other categories of persons who cannot give deemed consent, such as children or adults lacking capacity. And the third level of consent is consent itself, which means the giving of a permission or an agreement that is voluntarily and freely given or made for the use of human cells, organs and tissues, A, for the purpose of transplantation activities, post-mortem examinations, anatomical examinations or public display, and B, in respect of which purpose the person giving consent has received information sufficient to allow that person to understand the nature, risks and benefit of the proposed purpose. So this form of consent could be provided by the donor when they are still alive or by a designated family member after they are deceased. Also, the term child means a person under the age of 18 years, noting that deemed consent does not apply to children. So appropriate consent must always be provided from a parent, guardian or person with parental responsibility before organs or tissues can be removed for transplantation from a child. Part 2 is titled Transplantation and is likely the section that most people are concerned about, so this is where we will focus most of our attention. Section 10 confirms that where deemed consent applies, as in where a deceased adult has not included their name on the HSE opt-out register, and where there is no objection to transplantation activities, which is a defined term, by the designated family member, then the designated family member will be required to confirm this in writing in the presence of a witness. It should be noted that deemed consent only applies to this part 2 of the Act, so deemed consent only applies to transplantation. Just to note that this is the first time that the term deceased adult is used in relation to donation. And the reason I am highlighting this is because there are over 150 defined terms in the Act. However, deceased adult or deceased person is not one of them. Now, literature outside of the Act suggests that organ donation only takes place after brainstem death or cardiac death. But it seems to me that the most important definition in this legislation, as in what does deceased mean, should be clearly defined in the Act. Section 10 also confirms that appropriate consent only applies to the following: a deceased adult who has not included their name on the HSE opt-out register, a deceased child, the donation of an organ by a living adult, the donation of tissues and cells by a living adult donor, the donation of regenerative tissues and cells by a living child, and the donation of regenerative tissues and cells by a living adult who lacks capacity. Where appropriate consent is provided for any such person, the consent must be provided in writing in the presence of a witness, and a copy of the consent kept on the person's records for 30 years. Section 11 states that a person cannot carry out a transplantation activity, which is a defined term, unless A, deemed consent and confirmation of no objection to the transplant has been secured from a designated family member, or B, appropriate consent has been provided. Section 12 states that any donation of an organ or tissues and cells from a deceased or living donor must be voluntary and unpaid, and any financial compensation given will render any consent provided null and void. That said, this Section 12 goes on to say that a living donor may receive financial compensation in relation to the donation of an organ or tissues and cells, provided such compensation is strictly limited to making good the reasonable expenses related to the donation, noting that the term reasonable expenses includes travel costs, accommodation costs, childcare costs, medical expenses, and loss of income, which could mean that the payout for donation is substantial in my view. Section 12.8 also states that nothing in this section should be construed as prohibiting a procurement organisation, which means a healthcare establishment, a team or a unit of a hospital, a person or any other body which undertakes or coordinates the procurement of organs and who is authorised to do so, from charging reasonable fees to cover the costs of procuring, retrieving, storing, testing or distributing human organs or tissues and cells. Again, this sounds like it could become a very lucrative business. The next section is one of the most worrying in the Act, at least in my view. Section 15, Preservation for Transplantation Activities, Deceased Persons, states that where an organ or tissues and cells from a deceased person are or may be suitable for procurement for transplantation activities, a relevant professional may A. Take such steps as are reasonably necessary for the purpose of maintaining such organs or tissues and cells for procurement for transplantation activities, and B. In relation to a designated family member, 1. Where deemed consent applies, seek confirmation that the designated family member has no objection, or 2. Where deemed consent does not apply, seek appropriate consent from the designated family member. That said, this section goes on to state that the steps just mentioned, as in taking such steps as are reasonably necessary for the purpose of maintaining organs or tissues for donation, may be undertaken before, during, or after the confirmation of consent has been obtained. So what the law currently states is that a registered medical practitioner or a suitably qualified person acting on their behalf can start to prepare a deceased person, which is not a defined term, for organ donation before seeking and obtaining any consent. Section 16, Certification for Transplantation Activities, Deceased Donor, sets out the only real protection in this Act to ensure that a person is actually dead or no longer alive before their organs are removed. This section states that a person cannot remove an organ or tissues and cells from another person for the purposes of transplantation activities unless A. Following a medical examination by a registered medical practitioner, he or she is satisfied that the relevant donor is no longer alive, and B. The confirmation or appropriate consent is in place. What bothers me in relation to this section 16 is that it is literally the only place in the Act where the term deceased donor is used. Throughout the rest of the Act, terms such as deceased adult, deceased child, or deceased person are used. And considering the only protection from removal of an organ from a person who is not dead is captured in this section 16, I would have expected there to be a very clear definition for who a deceased donor is, so that people could be assured that a deceased donor includes deceased adult, deceased child, and deceased person. So I find the ambiguity unsettling. I have no doubt that the state would argue that a deceased donor includes all categories of persons just mentioned, but I still find the ambiguity unsettling. Section 18 states that a deemed consent will apply if you meet all of the following criteria. 1. You have not included your name on the HSE opt-out register. 2. You were over the age of 18 years. 3. You were living in Ireland for at least 12 months before your death. And 4. You had decision-making capacity for a significant period of time before your death. Section 18 goes on to say that where a person has not registered his or her objection to the donation of his or her relevant organs on the HSE opt-out register, a registered medical practitioner must still seek consent from the person's designated family member before organ donation can be completed. And where the designated family member objects to the donation should not proceed. And the objection should be recorded in writing by the relevant professional and retained with the deceased person's medical records for 30 years. Section 21, consent by parent or guardian in respect of deceased child, states that a registered medical practitioner cannot remove any organ for the purposes of transplantation from the body of a deceased child without the appropriate consent, which in the case of a deceased child means consent from a parent or guardian of the deceased child. The next section is probably what a lot of parents will want to know. So section 21.5 states that where one of the parents or guardians of a deceased child has provided consent and the other parent or guardian objects, the consent provided by the first parent or guardian has no effect and is deemed invalid. So for deceased children, both parents or guardians must consent. Section 22 deals with conditions in relation to donation of organs by living adults. Section 25 deals with conditions in relation to donation of organs and tissues and cells by living adults who lack capacity. Section 26 deals with conditions in relation to donation of organs and tissues and cells by living children. Then we skip to section 32, which deals with the relevant organ donation opt-out register. The important parts under this section are as follows. 1. Where you have included your details on the HSE opt-out register, the HSE should contact you to confirm the details are correct. 2. Only the HSE is meant to be able to access the information contained on the register. 3. The HSE can amend or delete details entered into the register to ensure it remains accurate. And 4. An application to the HSE to include your details on the register must be made in writing, be in such form as the HSE may specify, and contain the following details. Your forename, surname and any former surnames. Your mother's birth surname, your sex, your nationality and date and place of birth, your PPS number if any, and where known your individual health identifier number, and such other information as the HSE may from time to time reasonably specify for the purposes of maintaining the register. Now, several people have questioned whether or not you have to use the HSE opt-out register to confirm that you do not consent to organ donation. And while this section of the Act does not state that you must physically include your details on the register, in circumstances where you decide instead to phone the HSE to record your opt-out, they will be within their rights to refuse to include your details on the register if you refuse to provide all of the details I just mentioned. That said, it is worth noting that if you do not include your details on the HSE opt-out register, and where deemed consent applies because you have not included your details on the register, your designated family member must still be asked and give their consent to the donation of your organs before any transplantation can take place. Personally, I have not included my details on the opt-out register as yet, as the process makes me somewhat uneasy. That said, I am very comfortable that my family would know my wishes and would follow my wishes should an occasion arise where organ donation becomes a reality. But if I were not assured that my family would follow my wishes, I would likely include my details on the register. Section 34 confirms that where a person has included their details on the HSE opt-out register, that person's organs will not be removed for transplantation at death. Now we'll move to Part 3, which is titled Pathology Practice. Part 3 applies to all post-mortem examinations conducted in Ireland, distinguishing between coronial examinations, meaning exams ordered by a coroner, and non-coronial examinations, which are exams that are generally conducted for medical, educational or research purposes. The majority of this section of the Act therefore focuses on non-coronial examinations, as consent is not needed for exams ordered by a coroner. Section 41 confirms that post-mortem consent must be in writing, signed by the person giving consent in the presence of at least one witness, noting that the consent can be withdrawn at any time prior to the commencement of the post-mortem exam. It should also be noted that consent to post-mortem examination can be limited to a specific region of the body, tissues or organs. In relation to non-coronial post-mortem examinations, consent may be provided by the following individuals. A. In relation to a deceased adult, by the adult the subject of the examination, where he or she has, prior to their death, consented to a non-coronial post-mortem examination, or by the designated family member of the deceased adult, where the deceased adult has not, prior to his or her death, consented to a non-coronial post-mortem examination being carried out. B. In relation to a deceased child, by a parent or guardian of the deceased child, even where the parent or guardian has not reached the age of 18 years, noting that the parent or guardian should have regard to any previously expressed wishes of the deceased child in proportion to the child's age, degree of maturity and decision-making capacity at the time of expressing those wishes. Also, where one of the parents or guardians of the deceased child has provided post-mortem consent but the other refuses, the post-mortem activities should not proceed. C. In relation to a fetus, the mother or a person acting on behalf of the mother, even where she has not reached the age of 18 years. Section 50, Commercial Purpose and Consent for Use, states that where it is intended that a part of a body of a deceased child, a deceased adult or a deceased fetus, which is removed during a non-coronial post-mortem examination, be retained and used for commercial purposes, including use by a pharmaceutical person, the person in charge of the hospital concerned must first give his or her approval, and where the person in charge of the hospital gives their approval, a registered medical practitioner is thereafter required to seek consent of the parent or guardian of the deceased child, family member of the deceased adult, and the mother or person acting on behalf of the mother of the fetus. And without any such consent, the part of the body should not be used for commercial purposes. Section 50 goes on to say that a person or hospital shall not receive financial compensation or other non-financial inducements for any part of a body removed during a non-coronial post-mortem examination. So this part of the Act is suggesting that hospitals and relatives of deceased persons will be handing over body parts of deceased persons to pharmaceutical companies without receiving any financial compensation. Well, I certainly don't believe that. Section 51, Application by Minister to High Court, states that the Minister can make an application to the High Court to seek an order permitting a non-coronial post-mortem examination on a deceased adult, child or fetus without post-mortem consent in exceptional circumstances, including A. Where such non-coronial post-mortem examination is required in the interest of public health, and B. Where there is a risk to public health if a non-coronial post-mortem examination is not carried out. Personally, I would not be too confident in what is deemed to be in the interests of public health, considering that these same TDs locked the public down for 716 days for a coronavirus with a 98% recovery rate. To add insult to injury, Section 51 goes on to say that notice of every application made by the Minister to dispense with post-mortem consent should be served on the designated family member of the deceased adult, the parent or guardian of the deceased child, or the mother of the deceased fetus, unless the court decides that notice should be disregarded entirely. Next, we move to Part 4, which is titled Anatomical Examination. This Part 4 confirms that an anatomical examination means the use of a body or any part of the body for the purposes of the study and practice of the science of anatomy. Section 63 confirms that only the donor themselves may consent to their body being used after death for anatomical purposes, with any such consent being committed to writing and signed by the donor. This Section 63 also states that the donor cannot be compensated for their consent except for financial assistance with the provision of a coffin and transportation to a place of burial, otherwise the consent will be rendered null and void. Section 64 confirms that where a person has consented to the use of his or her body after death for the purposes of anatomical examination, the donor's body may be brought to a licensed institution and embalmed or otherwise preserved before the death has been duly registered in the Register of Deaths, but that no anatomical examination can take place until a medical certificate setting out the cause of death has been signed and furnished to the licensed institution in respect of the body. Next, we move to Part 5, which is titled Public Display. This Part 5 confirms that public display means, in relation to a body of a deceased person, an exhibition, show or display in which the body, body parts or the tissue of a deceased person is used for the purpose of being exposed to view, whether or not free of charge, by members of the public. Section 85 confirms that the body of a child, human fetus, embryo or gamete cannot be used for the purpose of public display. Section 86 confirms that there is a licence required for public display activities. Section 87 confirms that only the donor themselves may consent to their body being used after death for public display purposes, with any such consent being committed to writing and signed by the donor and witnessed by at least one person. The donor must also confirm the duration of time that they consent to their body being used for public display purposes. Any person who provides any such consent is entitled to withdraw their consent at any time before his or her death. This Section 87 also states that the donor cannot be compensated for their consent except for financial assistance with the provision of a coffin and transportation to a place of burial, otherwise the consent will be rendered null and void. Section 88 confirms that no public display activities can take place until a medical certificate of the cause of death of the donor has been signed and furnished to the organisation that intends to display the deceased person's body, who must hold a licence to do so. And finally, Part 6 is titled Miscellaneous and allows for the amendment of other pieces of legislation such as the Health Act 2004, the Medical Practitioners Act 2007 and the Assisted Decision Making Capacity Act 2015. This Part 6 also confirms that the Anatomy Act of 1832 is repealed and sets out offences and penalties for breaches of the Act. Some, but not all, of this Part 6 was enacted on the 17th of June 2025. That concludes our review of the Human Tissue Act 2024. On a personal note, I would like to say that there is a great deal about this legislation that I find unsettling, including the following. 1. The introduction of silence means deemed consent. For the past number of years, government, media and NGOs have gone to great extremes to hammer home the idea that consent must be affirmative, informed and voluntary to be legally valid. Whereas under this new Act, provided we are only referring to the confiscation of your body by the state, silence means consent. 2. The fact that the term deceased is not defined in the Act. 3. The fact that a living donor can be paid financial compensation for their organs, tissues and cells, thereby incentivising the sale of organs. 4. The fact that an organ procurement organisation can charge what is referred to as reasonable fees to cover the costs of procuring, retrieving, storing, testing or distributing human organs or tissues and cells, thereby making organ donation a legalised business. 5. The fact that a registered medical practitioner can start to prepare a deceased person, which is not a defined term, for organ donation before seeking and obtaining any consent. 6. The fact that it is not clear whether the protection offered to a deceased donor, which requires a doctor to certify that they are not alive prior to transplantation, includes deceased adult, deceased child and deceased person. And 7. The fact that the Minister for Health can make an application to the High Court to seek an order permitting a non-coronial post-mortem examination on a deceased adult, child or fetus without the consent of the person or their designated family member, and that the judge in the case can also decide that the designated family member does not have to be given any notice of the application made by the Minister. Many of you will be aware of the World Economic Forum's slogan of "You will own nothing and you will be happy." But this slogan has taken on a darker meaning with the commencement of this Act, so that now, even in death, you will own nothing, not even your own body, unless you agree to include your personal details on the HSE donor opt-out register. To be clear, this Act does not just presume consent, It presumes ownership, shifting the default from individual choice to state control. The parallel is stark: the promise of collective happiness at the cost of personal autonomy. With Ireland's new deemed consent system, unless you actively dissent, your body just becomes another asset for the common good. Another step towards a world where truly you will own nothing and we are told that you will be happy. Well, I don't feel happy about this law, and I know that I am not alone. Thanks for listening.